Good morning. My name is Rocco Galati. To my left is the Honourable Paul Hellyer, and to his left, Ann Emmett. We're here today to announce the filing of a constitutional challenge on last Friday, October the 21st, against the CETA, the trade accord between Canada and the European Union. The challenge is based on four major prongs, and that is that first, that the federal executive does not have the constitutional authority to unilaterally bind the country without the treaty going through Parliament first and being enacted. And even if it were enacted through Parliament, even Parliament cannot encroach on exclusive provincial rights and other constitutional rights that are not the exclusive purview of the federal parliament. The second challenge is that the majority of the terms of the CETA actually encroach on exclusive provincial rights such as natural resources, education, health, property and civil rights, the licensing of professionals, the qualifications of professionals. Those are all exclusive provincial jurisdiction, and this treaty, in its opening chapter, in Chapter 2, the executive undertakes to make sure that all levels of government, including the provinces and the municipalities, comply with the treaty, which of course the federal executive nor federal parliament have the constitutional jurisdiction to do. Thirdly, what the treaty does is set up a foreign tribunal to adjudicate disputes between private corporations and the government of Canada when private corporations cannot engage in the business they want to engage in because a province or other entity which has exclusive jurisdiction over the matter says no. Then we as Canadians have to compensate that company. So what that does in effect is it eliminates the pivotal lever of what maintains our constitutional democracy, and that's a fair and independent judiciary. So what we have is a tribunal that's going to sit in Ottawa when the dispute is heard, deciding issues of Canadian property, Canadian rights, and Canadian constitutional rights, but is beyond the reach or judicial review of Canadian courts. And lastly, what the CETA provisions do is eliminate subsidies, monopolies, and state enterprises that are there for the benefit of maintaining social welfare and economic programs for public welfare. And basically this treaty, virtually all of it, covers every single social program. The only three exceptions in the treaty are national security, taxation, and cultural industries. So everything else is up for grabs for private exploitation by foreign corporations, overriding the Constitution of Canada and overriding the rights of Canadian citizens who are resident here. And with that, I'll turn it over to Mr. Hellyer before answering any questions.
Thank you, Rocco, and thank you for taking the case. We've been concerned about it for a long while, as you know, and now it's de facto, and we're on our way. And I know that everyone's feeling very confident because you're the one that's going to plead our case, and I would expect to win on behalf of the people of Canada. Well, the title of this little 5-minute expose I have is entitled "Why I Am 100% Opposed to CETA." And I guess for this, in one line, it would be to save the Prime Minister from making the biggest mistake that any Prime Minister has made in the 67 years since I first set foot in Ottawa. But then, to refine that a little bit, there are two profound reasons for opposing the ratification of CETA. First, it would be illegal. It would result in a unilateral change in the Constitution of Canada. And that is outside the power of both the government and Parliament. The second reason is that to ratify CETA would be monstrously immoral. It would be the biggest betrayal of Canadian rights and privileges in the history of the country. Not only would it give foreign banks and corporations greater rights in Canada than those enjoyed by Canadian citizens, which is indescribably wrong in my opinion. It would give foreign bankers an effective veto over use of our most valuable financial asset, the Bank of Canada, at the very moment when we need it most. The situation today is reminiscent of the 1930s. In 1938, there were no jobs in Canada, none. Then the war came along, and pretty soon everybody was working, either in the armed forces or building factories or making munitions. And you say, where did the government get the money to accelerate growth to this extent, to do these things? The answer is that the Bank of Canada printed it. P-R-I-N-T-E-D, it. The money creation function was shared between the Government of Canada and the private banks. This system was maintained after the war and helped pay for our large infrastructure projects. The St. Lawrence Seaway, the Trans-Canada Highway, the distant early warning line. Some of you may not remember, but there was a line of radar stations built all around the periphery of the continent, very expensive, and the Bank of Canada helped the Government of Canada to pay for that installation, as well as to help us pay for a very comprehensive and much admired Social Security system. All of this was accomplished without significant borrowing and with inflation in line with other OECD countries. Then in 1974, the governor of the Bank of Canada abandoned the needs of his shareholders and started taking his orders from the Bank for International Settlements, that is controlled by the elite international banking cartel. The result for Canada is that because we had to then borrow in the market, from fiscal year 74-75 to 2013-14, we had to pay $1.17 trillion, that's $1 trillion, in interest on debt. Almost all of it unnecessary. All of that, plus decades of underfunding for all of our essential services. We switched from prosperity to austerity, and the international banking cartel ended up with a monopoly over money creation. Well, all of this has to be reversed. The Canadian government gives the Parliament of Ottawa the absolute right to create or to have the Bank of Canada create all of the money necessary to meet the legitimate needs of the Canadian people. And as an aside, we need an infrastructure bank. Canada needs an infrastructure bank like it needs a hole in the head. We don't need it because we have one. And it worked from 39 to 74, 35 years. It worked like a charm, gave us the best 35 years of the century, and all we have to do is learn from history and do something similar again. Well, in fact, there is a plan called a social contract between the government and people of Canada, which is available to Parliament now. And this plan calls for the creation of $150 billion a year for 7 years to be split between Ottawa and the provinces and territories on a per capita basis. But if CETA were ratified and implemented, prosperity would never be restored, nor the backlog of needs met, because European banks would sue Canada for tens or hundreds of billions of dollars if we denied them the opportunity to lend us the money and buy up our real assets for 5 cents on the dollar and keep us in poverty forever. The war between the rich and the poor that the rich have been winning would be over. So CETA must not only wither on the vine, but die on the vine and become nothing more than a footnote to history. Thank you.
When asked if CETA meets the requirements of the Constitution, the International Trade Minister, Christina Freeland, said absolutely. I got another quote here. The University of Ottawa constitutional law expert, Errol Mendes, says you're going to lose this one. It's been long established that the Constitution gives the feds the right to sign and ratify treaties, just as it can deploy troops overseas without Parliament approval. Do you care to address that?
Well, firstly, on the trade minister's, elaborate explanation of why it's constitutionally valid as to what the federal government is doing, absolutely doesn't cut it for me. I don't know what she's basing her off the cuff response on. With respect to Professor Mendes, and I say this with all due respect to all professors who live in a secluded environment of academic discussion.
We call them ivory towers.
Well, I was trying to be kind, Paul. With all due respect, if I had $100 for every time somebody said that my cases didn't have a prayer, I wouldn't have to, ask my clients for money for representing them on those cases. The fact of the matter is that prior to the Harper government engaging in negotiations on the CETA, the Parliamentary Research Library was asked to do a paper on the source of the constitutional authority for signing treaties, of which I have a copy, because this is the third time I've raised this issue in the court since 1998, and the first two times it did not get resolved by the courts to its conclusion. What that research paper from Parliament, which was floated to the government, states is that this whole notion of constitutional authority to sign treaties by the executive is in flux, and they stand on the old pre-patriation notion of residual crown prerogative. Back in the days when Westminster in England, the executive, Her Majesty the Queen, used to sign these treaties on behalf of all the dominions. That evolved in 1935 to allowing the Governor General, as her designee here in Canada, to sign on behalf of Canada. What's happened in my view, and with all due respect to Professor Mendes, who's probably never thought about it, is that the patriation of the Constitution extinguishes residual crown prerogative, which is the power in the Queen to exercise power that Parliament or the Constitution has not taken over. The House of Lords in England has made it clear that Her Majesty the Queen has no more role in Canada. So, in 1998, in a case called Fogel that went to the federal court where the same issue was being litigated, the government moved to strike the claim based on the fact that this was a frivolous argument, this idea that the executive didn't have the right to sign international treaties. The court refused to strike it on that basis, and in the written judgment said whether or not crown prerogative still exists after the patriation of the Constitution in 1982 is a serious question to be resolved. The court didn't hear the case because in the context of multilateral agreement on investment, which was the case, the agreement was not ultimately signed by the Canadian government nor the other 28 OECD countries, and therefore the case, the court decided they weren't going to hear it because there was no treaty. However, on the issue that we're putting before the court, the federal court has already decided that this old notion of whether or not crown prerogative exists to give the executive the authority to bind Canada this way is a serious question to be determined by the court. Now, is there a guarantee we'll win? No, but I stand firm on the representation that we're on solid legal ground here. You cannot have the executive knowingly sign away provincial rights with respect to provincial programs and provincial property in Canada and have a foreign body come to Canada and decide the rights of the province and of Canadian citizens under domestically, including constitutional issues, and not have our courts have a say in it. I mean, how ludicrous is that?
And if I might add, the same argument applies to federal rights, including the unlimited jurisdiction of the Parliament of Canada over money and banking, which would be compromised by the treaty and would be in effect rendered ineffective, so that we couldn't use an asset which is our most precious financial asset in the whole country.
Well, doesn't the argument that you're making here go back to the COMER versus Bank of Canada case?
Well, the Comer case is a slice of this CETA Accord, yes. Yes.
And would the judge not say that perhaps he's not willing to rule on this CETA case until the BOC case has been dealt with?
Well, no, one doesn't hinge on the other, Lawrence. The two cases are legally different. There's similarities, but Mr. Hellyer is quite right that what CETA does through the back door is it allows foreign banks and insurance companies the right to say, well, Bank of Canada can't have any more say in the private banking industry because that infringes our treaty rights to compete with private banks. And so here you have a public institution, a public bank, set up by an act of parliament that has to take a back seat to the treaty rights of private corporations. It's completely ludicrous. Listen, just to draw you an analogy, what's happening here is that if you think about the irony that we patriated our Constitution in 1982, what this treaty does, and any treaty of this magnitude does, is literally revert us back to the rule of divine rule of kings. The only exception is they're not on thrones now. They're in a numbered company that floats around the universe and around the planet, and every government and every constitution has to take a back seat to these corporations. And they affect this not through democratic process, in Canada at any rate, by passing it through Parliament and consulting citizens and seeing if it's constitutionally permissible, but they simply do it by executive fiat. They get together in private and in secret for 8 years. They present a text. This is the main text of the CETA right here. If I had printed the annexes with all the products and details, it would be 7-8 times as high. And so we get this, and they say we're signing it, and now the country and the Constitution and the Canadian citizens are bound just by executive fiat. Well, it's not an exaggeration to say in another time and place, that's the same as saying, l'État c'est moi. You know, the Prime Minister saying, I am the state.
I'd like to put a question to you about, further on this point about Crown prerogative. Now, if you're talking about the fact that the Prime Minister cannot invoke the Crown or royal prerogative in signing treaties, that has implications not just for CETA, it seems to me, but for every trade agreement that's been signed by Harper over the last, or for that matter, even NAFTA.
Well, to the extent that Parliament didn't later ratify through an act of Parliament, yes. But to answer your question, if Parliament has ratified it, the courts may say, well, that cured the problem. However, when you look at the terms of NAFTA, they still suffer from the same unconstitutional provisions that Mr. Hellyer and I have been talking about, and that is they encroach on provincial rights. The judicial mechanism for determining Canadian rights on Canadian soil under the Canadian law and Constitution is decided upon by a foreign body not subject to our judiciary. And there's the other aspect of our challenge, too, that is a bit more difficult for people to try to grasp their mind around. We also say that it is unconstitutional for our Parliament even to grant a fictitious foreign non-entity domestic rights and international rights which trump the rights of legislatures and statutes. This was tried from 1608 to 1970. In 1608, Lord Cook They tried it in a case called Sutton's Hospital. The English court said you can't give a corporation existence out of the domestic country from where it's created. And they tried it all the way on, off and on. Adam Smith said this was a crazy idea. In the World Court in 1970, the World Court rejected this argument that a corporation can exert existence in more than one jurisdiction, the jurisdiction where it's created. And so what you have, you see it, what you have is you have this new royalty of multinational corporations governing, and you get the result. And they have a Panamanian bank account, and you see the result of the system. And people and constitutions around the world are supposed to take a back seat to this. This is insane.
I might add, if we don't crush CETA, then we'll turn around twice and we'll be faced with the Trans-Pacific Partnership,
Right.
which is even worse and presumably has a bigger text.
And could you comment on other actions involving Crown prerogative, like deploying troops abroad? You're essentially arguing that even that is invalidated unless it gets prior or eventual approval by Parliament?
I've argued that in the perimeter fence case. Listen, everybody, there's an old bad joke that a lot of lawyers, jurists, and law professors have only two operating parts, and I say that's partly true, but I like to talk out of my mouth because it's closer to my brain. Others like to talk from the other end. The executive does not have the constitutional authority, and I filed against Prime Minister Kretchen when this happened in Kosovo. The executive, contrary to what Professor Mendez says, does not have the unilateral constitutional right to send troops abroad. The sending of troops abroad and/or the use of the military in Canada, we also challenged it at the Guffison Lake uprising in BC, are governed by the Emergencies Act, which is the new version of the War Measures Act. Under the law, all military excursions, whether they be domestic or international, have to be through the Emergencies Act. When you send troops abroad under the Emergencies Act, there has to be a committee, a parliamentary committee of all the parties in the House that oversees the operations 24/7, and then after the emergency is done with, has to issue a report to Parliament and report whether or not the use of force was justified. Now, of course, laws in the Constitution are very inconvenient these days. So people think, the Governor-General is the Commander-in-Chief of the Armed Forces, therefore the Governor-General can do what he or she wants. No. And, the prohibition against sending soldiers out on the streets the way they did in Guffison Lake contravenes the English Bill of Rights, which is still part of our Constitution, that you cannot, in peacetime, quarter an army and use an army on your own people. It's unconstitutional. The fact that these things happen and the fact that they're not challenged or that the courts haven't adjudicated doesn't mean that they're legal. And so Professor Mendez is wrong on that point, drawing that analogy on that point. The other thing I'd like to say is, and we make this clear in the statement of claim, is that if you look at treaties that stem from the exclusive jurisdiction of the federal government, when a treaty is signed by the federal government where it's the exclusive jurisdiction of the federal government, like, for instance, criminal law, those treaties are only signed pursuant to acts of Parliament. For instance, extradition treaties have to comply with the Extradition Act. The mutual assistance for taking of evidence and executing search warrants is similar. There's an act there. The return of children when they're kidnapped by one of the parents under a family law dispute. There's a Hague Convention for the return of children. Now, the federal government signed that, but it's funny, it's the exclusive jurisdiction of the province. It has no force in Canada unless the provincial parliaments pass it under their family law legislation. Ontario has passed it, but because it's the exclusive jurisdiction of the province, custody and access, it has to see approval and enactment by the province. With trade deals, they don't do this because it's inconvenient. They know very well that they're trampling and stomping on jurisdiction that's not theirs. So they fall back on this quaint right of divine rule that goes back to Versailles and Napoleon as their basis, literally. Residual crown prerogative. Well, just try to break that down. What that means is we can rule over provincial and federal parliaments at whim. Well, where did we see this before? Certainly not in any modern post-1867 constitutional framework. So we're literally regressing to the notion that they can simply govern by fiat. Royal fiat at that. When our monarch says you're on your own in 1982, I have nothing left to say in Canada. So analyze that.
And on that, on the issue of encroaching on exclusive jurisdiction, I mean, like there's been several lawsuits already under NAFTA, and like one, of course, one example, Quebec banning of fracking,
Right.
and that's being challenged. I mean, I'm wondering, based on what you're saying, one could argue that Quebec could just comfortably ignore this. I mean, even if you have you're signed on to these agreements, but one could challenge the ability to, or challenge lawsuits on that basis going forward.
No. You're missing the point here, Michael. No, Quebec can tell any company get lost, and the feds don't have a say over it. If they say no fracking, no fracking. Except that the company who wants to come in to frack had intended to make $250 million. So the lawsuit is not against Quebec, it's against the federal government and the taxpayers of Canada, who will have to pay that $250 million because Canada, in not being able to force Quebec to comply with the treaty rights, is in breach of the treaty. You understand?
Mm-hmm. But CETA does apply to subnational levels of government.
You're wrong. It's in the statement of claim. Chapter 2, Section 2, Sub 2, says that the federal government undertakes to ensure that the objectives and the enforcement of the treaty is implemented by all levels of government, including provincial and municipal. And I'm basically quoting almost verbatim. So the federal government is going out there and saying, I promise that everybody in Canada, including the provinces and the municipalities, will comply with the treaty, knowing full well they have, one, no business promising that because it's unconstitutional, and two, no way in enforcing that because it's unconstitutional.
Okay. I'm curious to know if we'd signed an agreement like this back in 2006, because, I mean, one of the concerns is that, the elimination of monopolies and the impacts on the ability to utilize the Bank of Canada, for example. I know that there's been a lot of concerns about, back during the 2008 financial meltdown, that one of the reasons that Canada survived it better than other countries is because of the superior bank regulations. Is it possible for you to kind of maybe speculate about how things might have been different if we'd signed an agreement like CETA with these sorts of provisions in place? How would that have affected our ability to survive the 2008 financial meltdown?
Well, you're asking me a banking economic question that although I have, a layman's educated guess and opinion, I don't feel in this context, Michael, that I'd want to answer. Perhaps Mr. Hellyer wants to answer that. I'm here to answer questions on the legality of this treaty, not on the economic impacts, unless,
And it is what we used to say, a hypothetical question.
Yeah.
Okay.
Yeah. Now, you mentioned something interesting, the monopolies. What people have to remember, most people probably don't know this, is that the notion of a monopoly goes back to the early 1600s, when there was an act in England passed called the Monopolies Act. And what the Monopolies Act said, and it arose out of the context of an idiot cousin to the monarch who didn't know how to make a living. So the monarch said, anybody producing, selling, and distributing playing cards will have to give a cut to my cousin, and did that by royal order, by fiat. Parliament said, no, 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 you can't do this. We can't have the executive deciding monopolies. Only Parliament can grant monopolies. And so since then, and it was considered a quasi-constitutional act under our system. So what does CETA do? It does the reverse of what you couldn't do with monopolies. It actually does away with parliamentary created monopolies for the public good. Again, by executive order. So we're back to 1623.
Well, speaking from a Manitoba example, we've got a Crown provider of energy known as Manitoba Hydro. What could we be expecting down the line if CETA were to go forward?
Just what we got in Ontario in anticipation of CETA going forward. It's going to have to go into private hands because it cannot operate, and if it doesn't, Canada is looking at probably, I don't know, what does Manitoba Hydro put out? How many billions of dollars? We'll be looking at a multi-billion-dollar lawsuit, claim at the International Tribunal against the Canadian government for not being able to privately complete in your hydro distribution. And the other thing you can expect is what we got here overnight. Our hydro bill quadrupled. Literally quadrupled overnight in the last 2 months. So that's what you can expect. Or the federal government will have to pay every company that tries to go in there and compete with Manitoba Hydro. And can't, because Manitoba says, no, this is a public utility, it's exclusive provincial jurisdiction, you can't come in here.
So you've got this, you filed the claim, and the government has, 30 days to respond? Well, what are their options at this point? If it seems they seem to be hell-bent, in Mr. Hellyer's words, to sign onto this agreement.
Well, it's going to be the usual, par for the course. This is not a statement of claim. If it's a statement of claim, it's the wrong statement of claim. If it's the right statement of claim, the plaintiffs don't have standing. If they have standing, they don't have a prayer. If they have a prayer, you shouldn't hear it anyway. The usual. That goes on with all these cases. I mean, what response can they give? Justin Trudeau knows he can't broker away provincial rights. He knows he can't broker away monopolies. He knows he can't broker away public utilities that belong to the province and the people. He knows he can't broker away municipal and provincial social programs. What are they going to say except, l'État c'est moi? Really, I mean, they disguise it in legalese, but we are the state. We do what the frigging we want. That's what they're going to say. And so that has to be challenged. Isn't that what they've been doing and saying since, NAFTA?
Mm-hmm. And I guess this is a legal point, but, just assuming Wallonia could have been somehow strong-armed into going along with CETA, does this, the tabling of this, filing of this claim in any way throw a wrench into the works, or could they sign ahead in spite of this challenge?
Who? Canada?
Yeah.
Oh, Canada can sign. I don't think this government is any better than the last government in caring what citizens say about their agenda. They're probably going to plow ahead and sign it, and we'll go to court and fight it. Now, with respect to Wallonia, as I mentioned in the piece that was put out in by the press yesterday, it's so ironic that everybody is dumping on poor Wallonia for what? For exercising their constitutional rights. They have a constitution that's very, very similar to ours. And everybody is dumping on them for exercising their constitutional rights and for respecting their constitution. Meanwhile, we ignore ours.
Well, it seems like a very significant event. I don't know, would either of you care to comment on the level of media interest in this story?
Do you want to go first, Mr. Hellyer? No.
You know more about it than I do.
All right. Well, it's with the Bank of Canada for the first couple of years, we had a virtual blackout. Although the story has gone viral, it's gone viral in an ironically corporate sense. It's the same story done by CP that's been that's been that's been broadcast, for which I'm grateful, because people at least know. So it's everywhere. But if you go to the mainstream media outlets that have carried the CP story, like CBC, like the Toronto Star, and other major newspapers, there's one thing that you'll notice missing from all of them. There are no bloggers or no comments allowed on the story. And I don't have to be paranoid to tell you I think that's on purpose, because they don't want others who come onto the story to see what the support level is for our challenge or not. In some of the few places where they do allow comments, for instance, in the Huffington Post, the comments are overwhelmingly in support of our challenge. So although the story got out, there's still I see pressure there to minimize its distribution by eliminating the comments. I'll be honest with you, when I go on to CBC or any other news outlet, I rarely go there for the news items. I'm always more interested in feeling the pulse of what people are saying in reaction to the news stories.
Is it possible for either of you to comment on how you see CETA would intersect with other trade agreements like NAFTA?
It's in the claim. So what happens? Under NAFTA, we have what is typical in these bilateral trade agreements. It's the most favored nation clause. So once we sign NAFTA, the United States of America and Mexico automatically get all the benefits that Europe gets under CETA, but they don't have to reciprocate anything back to Canada. So the liability is going to mount exponentially, not only under the CETA for companies who want to come here and do business and they can't, but by American and Mexican companies who then pick up on the rights in CETA that are not present in NAFTA, and they come here and they want to do business and they can't. And so it's like when we sign CETA, it's like attaching CETA to NAFTA, but on a one-way street, to the benefit of the Americans and the Mexicans, but not to Canada, because the Mexicans and Americans are not required to give us anything back.
Okay, I was just going to maybe move on, since I know that the COMER lawsuit was brought up earlier, and if it's not too much of a departure, I was wondering if you might give us a bit of an update on where things sit there following that last decision by Justice Russell.
We have a hearing date, I can't remember the exact date, if it's the 7th or the 9th of December.
The 7th.
The 7th, December 7th, we're in the Federal Court of Appeal. And then from there to the Supreme Court.
Okay.
Okay. I know there's been a lot of misunderstanding, and this is, not that I'm critical as a lawyer of non-lawyers, but it's, a lot of people misread the court judgment, and I see in some alternative press the misunderstanding that the Bank of Canada case has been once and for all killed by the court. That's not true. We're still in the Court of Appeal. It still has to run its course to the Supreme Court.
The Jean Charest last night on CBC was asked about this, was talking about the Sita case, and he said, one scenario could be that the Belgian government just goes ahead and signs, ignoring the opposition of Wallonia, and say to the Wallonian Parliament, just sue me. What's your response to that?
3 responses. 1, that's John Charest saying, "L'État c'est moi aussi." He's just acting like a divine despotic king. Oh, what a statement for a premier of a province to make. Just ignore the law. Can you imagine? Number 1. Number 2, we have to remember that Mr. Charest negotiated for the Harper government, the CETA, in the early days. He was right up there, front and center. He was negotiating that. And number 3, personally, I met Mr. Charest in Sherbrooke during the Meech Lake Accord, which I opposed, and I was happy that Elijah Harper stopped. And I wasn't impressed by his views of the Constitution or the rule of law then, I'm not now.
If I can just ask a simple question and get a response from the 3 of you. What is the why behind the CETA agreement? Why is this being tabled? Why is the government, our government, coming forward with such a monstrosity? What's the agenda behind it?
If I may say so, I think that's a little broad for this discussion. It would take another book, as the saying goes.
Good morning, Ann, Paul, and Rocco. Thank you for being here and for doing this. On the behalf of Canadian bank reformers, I just want to ask a basic question for the general public that's out there who aren't very educated on CETA and the effects that it can have on their lives if it's passed. So can you bring up maybe some solid bullet points on how it's going to directly affect their lives so that they understand the significance of why you're doing what you're doing right now?
Okay, just brass tacks. The government will no longer be, the provincial governments will no longer be able to, without penalty to the federal government, give subsidies for healthcare, education, all the social programs that you see municipally in terms of, community programs, welfare, and all of that, okay? If they do so, then the federal government, if it breaches a right, will have to pay. So how does the federal government avoid paying because the provinces won't let them do it? Well, behind the scenes, the federal government will use their spending power to say to the provinces, look, if you don't play ball on this, we'll cut our transfer payments to you for education and health. That's been how they've been able to implement the NAFTA when it's encroaching on provincial rights. So expect exorbitant utility bills, hydro, you've already seen them.
Mm-hmm.
Expect a cutting of educational program, a cutting of health benefits, on and on and on. So education, health, social programs, roads too, because private corporations will be able to compete with the government. It used to be that the government built highways. Now they're going to come in and privatize the roads, bridges, on and on.
So is there anything that you want to ask Canadian citizens to do in terms of what's going on here, how to help perhaps? Is there anything that anyone can do to help you guys in your movement and what you're doing?
I first became involved politically, really, with NAFTA. I was asked to prepare a press release, and I certainly don't know legalese, and I did what I could to get information on it through my MP, who first of all gave me a little propaganda blurb, and I said, I don't think that's adequate. And when I look at this, I think how funny that is. And I hadn't gone through very much before even I could see what free trade was all about. First of all, it was a lie. Free trade deals are neither free, they're certainly less than free, and they are a lot more than trade. And it's long past time when we should recognize that free, as Paul suggested a moment ago, this is a whole other book. What is this free trade tactic really all about? It's about taking away democracy, for one thing. It's about rendering the nation state less than sovereign. It's about all those things that Rocco just said. It's about a neoliberal agenda being put in place so firmly globally that we are stripped of all our rights. And we will be living in what they used to talk about as the New World Order. And what can people do and what should they do? The first thing to do is to learn what you can. The resources today are tremendous. Good people like Michael Hudson, like Joseph Stiglitz, are telling it as it is. These are mainstream people. Stiglitz was chief economist for the World Bank. And he wrote a book entitled The Price of Inequality. And what you're getting, of course, with all of the measures that are going on, and debt, of course, is the other main tactic, what you're getting is a growing inequality and a horrendous transfer of power from the people to the corporations, from governments to corporations. Governments have been put in their place. This is a monstrous moment in history. We are living in a defining moment, I think. And the first thing we need to do is to help one another to know enough, to know what we're up against, so that we can act. Anyway, here ends.
Thank you for that.
You're welcome.
And Paul and Rocco, thank you.
The case is well stated, even though it was understated. This is a big deal. We've been discussing it. Public knowledge is almost non-existent when it comes to the motivation for these deals and what the game plan is. So the public has a responsibility to itself, primarily, to find out before it's too late.
Can I throw out one more question? It will be my last one. I'm just curious, because I know there's a particular concern, I know from Mr. Hellyer's perspective, about the First Nations and impacts there. I know that the First Nations have signed treaties with the Crown, and I'm kind of curious about maybe a sort of a working case study or example of how CETA, in combination with the Canada-China, FIPA, and other trade agreements, would undermine their welfare.
Well, on the face of it, Michael, on the face of it, the CETA says that it doesn't cover any programs or federal legislation with respect to Aboriginal rights, and that sounds comforting. Well, it just doesn't cover what the federal government may do with Aboriginal rights, but there's all these back doors that still will affect Native rights and treaty rights to property, to resources, that will be equally affected and trampled on as the provincial rights.
I would just like to add something positive here. When we began, COMER, that is, the Committee on Monetary and Economic Reform, in the mid-'80s, no one was talking about any of these things. The level of awareness today is infinitely higher than it was. Absolutely. And there is a vibrant, growing global movement, for example, for monetary reform. Rocco and I were asked by a group in Montreal if we would go to an event that they would organize, and that was videoed. They translated it into French. It's gone all around the world. We had a call. We get messages from around the world, and we had a call from a group in Spain, for example, to say that they had translated it into Spanish, and they wanted us to know how it could be, how we could access it in Spanish. In August, there was a social forum in Montreal that drew people from all around the world. It was the first time it's been held in the World Social Forum in North America. And there we met this chap that I've been communicating with for a couple of years from Spain. And also, there was someone from Germany, a young man, 24. I couldn't believe how good he was, how much, and he was only 24. And we had a chance to have 3 workshops. And this chap from Germany and the chap from Spain participated and made wonderful presentations in the course of those workshops. And we've been invited to an international conference on monetary reform in Berlin in February. It's going on all over. My favorite message came from the Netherlands, and they quoted Nietzsche, who said, "And those who were seen to be dancing were thought insane by those who could not hear the music. And our task is to turn up the volume."
Absolutely.
You're here, and on that splendid note, I think we should adjourn, thanking Rocco very much for making his facilities available this morning. Thank you.
Thank you.
Thank you, Rocco, for everything.